Hello everyone, my name is Jen Nolan and on behalf of Musculoskeletal Australia, I'd like to warmly welcome you to our webinar this evening on employment law, rights and entitlements. We know that this topic is of great interest to many people, especially given that the great majority of people with musculoskeletal conditions are of working age. I would like to begin, however, by acknowledging the traditional custodians of the land from which we are broadcasting this evening, the Boonwurrung people of the Kulin Nation, and pay my respects to their elders past, present and emerging. On behalf of Musculoskeletal Australia, I'm very happy to provide you with our list of free consumer webinars for 2021. We have a great and diverse list of topics ranging from issues concerning women with rheumatoid arthritis and pregnancy to pain management and to diet when living with a musculoskeletal condition. If you haven't already registered for the whole webinar series or for individual webinars, you can do so on our website. When you visit our website, you'll find an extensive range of information, films and videos, apart from our other initiatives and services, such as our peer support groups, our MSK Kids program, and recordings of our previous webinars and other key presentations. Remember to contact our National MSK helpline at any time via email or phone on 1800 263 265. You can also sign up for our regular e-newsletter on our website. The presenter for this evening is Jessica Dawson-Field. Jessica is an employment associate in Maurice Blackburn's Melbourne office. She helps employees navigate a wide range of employment-related issues throughout their working life. Jessica holds a Bachelor of Arts and a Juris Doctor. Before joining the firm, Jessica gained experience working in an employment and commercial litigation team for a top-tier commercial firm, a union, and as a research assistant at the Centre of Employment and Labour Relations Law at the University of Melbourne. Without further ado, I'll hand proceedings over to Jessica. Thanks very much, Jess.
Thanks, Jen. Thank you for that introduction, and thank you everyone for having me on the webinar tonight. We've got a bit of time this evening to go through employment law, rights and entitlements. Now, this is a presentation that we could probably fill a week or a month, going through all the issues, but we've obviously only got a limited amount of time this evening, and we're going to focus on some key concerns that might affect people with MSK. Now, in terms of the firm, just a little bit about us, Maurice Blackburn. We practice in a broad range of areas and we can be found in a number of different places across Victoria and Australia. So I'm in the Employment and Industrial Law team. We also have lawyers that work in a wide variety of areas, including work cover, road accident injuries, medical negligence, aviation law, will disputes. If it involves something that's happened in your working life, we can probably help with it. Or if it involves a medical injury, we can also probably help with it. So any doubts, I'll put some contact details at the end if there's anything that we can assist you with. In terms, just bear with me, in terms of what we'll cover this evening, we're really looking at 4 main topics. Firstly, what your rights are in the workplace, where they come from and how you can access them. Secondly, disclosing your medical condition, which I know is often a concern for people who have a medical condition that could or may affect their employment. Third, what your employer should do to keep you in the job. And fourthly, what your options are if you experience discrimination in the workplace. And as Jen said, if any questions come up, please put them in the chat and we'll try and answer them in the time we've got at the end. So first off, your rights at work. And you might remember that slogan from a union campaign that was run a number of years ago. But here we are is a bit of a list of some of the sources of rights and entitlements for you as an employee. So the main one that people identify with is the Fair Work Act, and that covers a number of entitlements such as your personal leave, protections from adverse action and unfair dismissal, which we'll cover a bit later on, the anti-bullying jurisdiction, which we'll also cover. It's really the source of the main employment law rights and entitlements that cover most employees. There's also state and federal discrimination law, which can be relevant for people with a medical condition, particularly in relation to reasonable adjustments. Depending on where you work, you might also have access to an enterprise agreement or modern award. They can provide specific rights and entitlements. We probably won't go into much detail about those tonight, but it's something to keep an eye on. Then you've got things like your own individual employment contract, and lastly, things such as workers' compensation. And that's, for example, bringing in a work cover claim if you're injured at work. So in terms of the first issue that was raised at the beginning, one of the key areas that often we're asked to advise on for people that might have a medical condition that affects their working life and could affect the work that they do I have to tell my boss? And that's a big concern for a number of people, and understandably so. So, our view is that unless there is a safety reason that you have to disclose your condition, there's usually no other legal requirement to do so. But on the flip side, there might be a benefit in doing so in some situations. So the benefit might be that if you disclose your condition, you might be able to seek what's called reasonable adjustments from your employer to make your working life more comfortable. And that's something we'll come to a bit later on when we talk about discrimination. Another dot point there, and one that's really important to remember, is, if you're in an interview or you're applying for a job, in some cases it can be unlawful for a prospective employer or future employer to ask you questions about your condition at the interview. And the test I usually sort of apply in these situations is, do they need to know? Is it essential to the job that I'm doing? And if it's not, just making a note perhaps during the interview or afterwards about what's happened, and thinking about getting some legal advice if that's appropriate. Now, turning to the next part of the presentation, which was looking at discrimination. And this is a really significant part of the law, and also a really significant part of the law for people with medical conditions, and also a number of other different attributes which are protected under both the Victorian law and the federal law. So what we'll cover this evening is really some broad ideas about discrimination and what it means. And what I've got here on this first slide is a bit of a shopping list of all the different acts which govern this area. So, in Victoria, we've got things such as the Equal Opportunity Act, the Charter of Human Rights and Responsibilities, the Racial and Religious Tolerance Act, and then at the federal level or the Australia-wide level, we've got things such as the Age Discrimination Act, the Disability Discrimination Act, the Racial Discrimination Act, and the Sex Discrimination Act, and also some protections that come from the Fair Work Act, which adopt some of the attributes in those other acts. So it's quite a complicated area, and often there's complicated questions about which act you might go under or where the provision fits. It's a whole complex question, but what I'm hoping to give you tonight is just an understanding of some of the key principles, how it can affect your working life, when you might want to get further legal advice, and what to keep an eye on. So I'm trying to make it sort of as practical and useful as possible. And if there's any questions that come up, as Jen said, pop them in the chat and we'll try and cover them off at the end. So in terms of what a disability is under the Discrimination Act, and for the purpose of this presentation, we'll be looking mainly at the Federal Act, so the Disability Discrimination Act that applies across Australia. It's got a very wide definition of disability. It doesn't just mean, physical injury. It can mean something that exists now, that used to exist, that could exist in the future, or because someone such as an employer thinks you have a condition and treats you differently because of that, or thinks you have a condition that has a certain, effect, which is often something we see with employers. They make assumptions about people's health and they treat you differently because of it. So it's a very broad definition, and I think sometimes people, approach it with a very narrow view, but just keep that wide definition in mind when thinking about discrimination. Now, in terms of what discrimination is, there's the common sense understanding of what it is, but there's actually also a very specific legal understanding or legal test about what it is. And effectively what it involves is if someone is treating or proposing to treat someone that has a condition less favorably than they would treat someone who didn't have that condition. So effectively treating someone, worse than if they didn't. So a good example might be, maybe there's two people going for promotion, and the only difference between those two applicants is one has a medical condition or one is a woman. You might be able to say, well, the act of promoting the other person is discriminatory because this other person was just as entitled to that role. Now that's a very simple, I suppose it's complicated, but a relatively straightforward example of what discrimination might involve. But it's really that example of, someone with an attribute, be it race, be it a medical condition, be it gender, be it parental responsibilities, being treated differently to someone that doesn't. The other way that discrimination can happen, and it's particularly relevant in a context of a medical condition where you might need alterations to your work, is if someone, so an employer, doesn't make reasonable adjustments for a person who needs them. And, the effect of making those reasonable adjustments is that that person is treated less favourably in similar circumstances. So there's a lot of legalese in that slide, but when you break it down, it's really that a person is being treated differently, less favourably, worse off than someone who doesn't have a condition. And you might, be able to think of examples in your own working life about where this has happened or, in your own situations. But I do like to just spend a bit of time explaining, what the legal definition is, because it can be a bit different to the common sense understanding as well. Now, the phrase I just mentioned before is really significant in employment law matters, and that's the phrase reasonable adjustments. And under the Disability Discrimination Act, and it's quite similar under the Equal Opportunity Act in Victoria, but under the Disability Discrimination Act, employers actually have a positive, so an actual obligation to make reasonable adjustments for employees with disabilities. So an adjustment to be made by a person, like an employer, is a reasonable adjustment, unless making that adjustment would impose what they call an unjustifiable hardship on the person. So a classic example, you might do a bit of a comparison, but say, for example, you've got a huge retail supermarket as opposed to a very small sort of family business. Now, the cost of a big retail company making minor adjustments, for example, by providing a step ladder or different shifts or a limit on what weight someone's lifting on a shift, is probably going to be of even less impact to that big company than it would be on a small company who might need to employ more staff or different staff to cover the work that perhaps a person with a medical condition who needs adjustments, has to do. And, unfortunately, it does mean that, sometimes in a bigger company or in a bigger organization, it might be easier to say that an employer should make adjustments as opposed to a situation where you're working for a much smaller company. And that's, a pretty unsatisfactory part of the law, but that's the way it is at the moment. So in terms of, and I've got a list here of what would be an unjustifiable hardship, but they're things like, the benefit to the person if that adjustment is made, the effect of the disability on any person concerned, and the financial circumstances on the business that has to make the adjustment. And I gave some examples before about what might be a reasonable adjustment, but some of the classic examples are things like offering someone a different workstation, flexibility around medical appointments, giving people the opportunity for a break, or even part-time work arrangements or shortened hours. They're quite common adjustments that people would seek. And in most circumstances, you would probably say that it's, probably reasonable for an employer to make such adjustments. Of course, it depends on the facts. And I've given a bit of detail here, and I understand you'll have access to the slides after, so please don't feel that you need to write all this material down. But just an example of where a very big company, so AusPost, effectively tried to not make adjustments for someone who had a medical condition. In this case, it was a psychological condition. And the adjustments that were sought by this employee were quite limited. There were a very small alteration to her duties, and the end result was that, and I should say also for a limited amount of time, the company said that they didn't want to effectively make those adjustments, and the matter was taken to court. And I think this is quite a good quote just about, how the reasonableness of these things is considered. But matters such as limited working hours, which are gradually increased, alteration to supervision arrangements, modifications to face-to-face meetings, minimizing conflict situations are necessary for a limited period are adjustments which could have been made. So just because your employer might not be willing to discuss adjustments or consider adjustments doesn't mean that the law is in their favour, and there's a lot of cases about this issue. Parking the reasonable adjustments point, another aspect that often comes up for us when dealing or helping clients who might have medical limitations or restrictions on their duties is inherent requirements. And what that phrase provides is effectively an opportunity for an employer to discriminate against someone, so lawful discrimination, if someone can't do what's called the inherent requirements of the position. So the way to think about it is your job might be, 20, 30, 40 different duties. Not all of those are essential or inherent. Some of those are, I guess, not as important or not as critical to your role, could be moved around, could be given to someone else. But if they're inherent and essential, and the classic example might be, well, if you're driving a forklift, you're going to need a forklift license, or if you're working in a supermarket, you might need to be able to lift above a certain amount. If you can't do those core functions because of a medical condition, the employer might have a basis to terminate your employment. And I'll get to a bit later on about, how that process might be conducted and some things to think about. But I just wanted to flag that as a part of the Act, which does allow employers to take action, which would otherwise, be discriminatory. Now, just bear with me. I'm just going to have a sip of water. So I've just provided a little list here for future reference about things that might be taken into account when determining if a person's able to carry out the inherent requirements of the particular work. So you'd be looking at things like the person's past training, qualifications and experience, what their past performance would be, any other factor that's reasonable. And I've just put there something I spoke to earlier, which is that an inherent requirement is something that's essential to the position. So often we will have a fight with employers about what is inherent to the job, what is an inherent requirement, and what's something that's not essential. So it's quite a common issue that we come up against. Now, in terms of what we've spoken about just now, the discrimination claims, if any of these situations ring a bell and you feel that, this is something that you've come across, unfortunately, there are quite strict time limits for these claims. So under the federal regime, because of some amendments a few years ago, it is quite strict, a 6-month time limit. That doesn't mean you can't bring it, but it can be more difficult to progress it. So we always recommend to people to get advice as soon as possible so you can understand what your claims might be and what time limits you need to be aware of. Because although the federal regime is 6 months, the state regime is actually 12 months. So you can see some of the complexity here about, the legal avenues and, how difficult it can be for people to access their rights because, the avenues in which you might get relief or go to court have limits on them in terms of timeframes. So I've just listed here some of the steps that happen with a discrimination claim. So first off, filing a complaint either with the State Equal Opportunity Commission or the Federal Human Rights Commission. The next step being a conciliation conference. If it doesn't resolve there, then it might proceed to VCAT, which is the State Administrative Tribunal in Victoria. And I should say I'm based in Victoria, so a lot of this guidance is Victorian based, or the Federal Court or the Federal Circuit Court for the federal jurisdiction. So some things that you could guess as part of this process might be compensation for loss of income and damages for hurt, humiliation and distress. And traditionally, claims in this jurisdiction were relatively small, compensation in this jurisdiction was relatively small, but there's been a real change in probably the last 10 or 15 years with some really significant amounts being awarded to, particularly in sexual harassment matters, which is different, but in that discrimination space, really significant quantums. Just a note here as well, and this is really just a explanation of why you should always get legal advice perhaps before embarking on these things, but there is capacity under the federal regime if you lose a case to have adverse, costs awarded against you. So it's just something, I always recommend to get legal advice because everyone's scenario is different. But just a couple of comments there for your consideration. Now, parking our discussion about discrimination law and options, and just to make things more complicated, there's also capacity to bring claims under a different regime, and that's the Fair Work Act. And interestingly, the Fair Work Act brings together a number of concepts from discrimination law in the adverse action provisions, and provides another avenue with some different, pitfalls to be aware of. So under the Fair Work Act, there's a prohibition against an employer taking adverse action against an employee because of a disability. And adverse action has a really broad definition under the Act. Adverse action can include things such as dismissal. So, it would be unlawful for an employer to terminate an employee because they've got a disability. Now, there's still that defense of inherent requirements that we'd have to come up against. The other adverse action definition, or the other part of the adverse action definition, is injuring the employee in his or her employment. And injuring has a really broad definition within the law, and it really means damaging or impacting adversely that employee's employment. So, if a good example might be that you just told your employer that you've got this medical condition, you're a casual worker, and all of a sudden you don't have any shifts. And you could say that, well, that's only happened because I've told the employer that I've got this condition and they've taken action against me because of it. So that would be an example about injuring in the course of employment. It's quite similar to this other phrasing, which is altering the employee's position to their prejudice. Again, talks about, detriment and damage. And then the last point being discrimination between the employee and other employees. So you can see how that pulls in a bit about the language of discrimination under the Disability Discrimination Act that we talked about, and then also the Discrimination Act that also exists in Victoria. So it's a bit of a multi-layered sort of area we're dealing with, where there's lots of different claims that might be available. And sometimes it's hard to pick the right one. Even as lawyers, it can be hard to pick the right one sometimes. Also within here, within this adverse action jurisdiction, is a protection for prospective employees to be protected. So a prospective employer should not be taking adverse action against a prospective employee. And that goes back to the example we started with about, an employer, asking for information during a job interview, which we might say they don't need to know because it's not essential to the job. If they, didn't hire someone as an outcome of that process, there might be an argument, depending on the facts, that they've taken adverse action against that employee by refusing to hire them or by offering them a job on terms and conditions which are putting them in a worse off position than others. So I should say also these provisions can apply more broadly than just employees as well. It can also sometimes apply to contractors and members of unions and all different things. So just bear that in mind, that depending on the scenario, these concepts might go much broader than just employment. But obviously, I'm an employment lawyer, so that's what we're dealing with here. In terms of time limits, again, for an adverse action claim, if you've been dismissed, and I'll talk about another dismissal claim a bit later on, unfair dismissal, which most people have heard of, but if you've been dismissed and you'd like to bring an adverse action claim, you've got even less time to bring that claim. You've only got 21 days. So it's a really short time frame. If it's about conduct that doesn't relate to dismissal, so if it's limited to conduct that happened during the course of employment, say that you were offered less shifts but you weren't terminated, although that might be a dismissal in some cases, or if you were, your hours were reduced, or you were moved to a different office, or there was some other adverse treatment that injured your employment, you would have 6 years to bring that claim. So just a note there about the time limits. As I mentioned before, there is another claim that people often come and see us about, which is the classic unfair dismissal. Now, an unfair dismissal is a totally different test to some of the discrimination concepts we've talked about before, but it can come up in the context of someone being dismissed or treated adversely at work. A dismissal is unfair if it's harsh, unjust, or unreasonable. And there's really a number of factors that need to be taken into account to make that assessment if it's harsh, unjust, or unreasonable. And that includes things such as if there's a valid reason related to capacity or conduct. So does the employer have a valid reason to terminate someone because, you know, they've stolen money from the till? Probably. But in some cases, if the employer's been really unclear about policies or processes or, you know, what the expectations of employees are, or they've sacked someone straight away rather than giving them a warning, there might not be a valid reason. The other thing to consider is whether the employees had the opportunity to respond to any reason for the dismissal. And that really goes to procedural fairness and the opportunity of an employee to put their side of the story forward and for the employer to listen to it. In some cases, it might, and I've just popped a case there, but in some cases it might be possible for a employer to dismiss someone on the basis that they can't do the job because of the medical restrictions or limitations in circumstances where there's no reasonable adjustments which would enable the employee to perform the role. So that's just a case I've popped in there. The other thing to be aware of, again, like the adverse action, there is a 21-day time limit to file your application. It's very short. Often people are still dealing with sort of the consequence of being dismissed and obviously making decisions about finances and, you know, other things. But if you are ever in that situation, or if you know anyone that's ever in that situation, just convey it's a very short time limit and it's very, very hard to get an extension on that time limit. You know, it's a very difficult fight to be having if you haven't filed in time. So I probably can't emphasize that enough. Now, in terms of another claim that might be available under the Fair Work Act, this is one that's not just targeted to, or not just related to discrimination because of a medical condition or disability or injury. This is much broader, and this is bullying. And under the Fair Work Act, there is a protection from bullying, and there's options. So under the Fair Work Act, bullying is repeated unreasonable conduct or behaviour, directed towards a worker or a group of workers that creates a risk to health and safety. So that provision covers most workplaces, not all. There are some exceptions that are quite technical. If you have been bullied, you have capacity to bring what's called a stop bullying application. And what that entails is applying to the Fair Work Commission to deal with a complaint about bullying. What usually happens is that it's listed for a conciliation. You have a conference before a member of the Fair Work Commission. If it doesn't resolve, it might then go to a hearing, and the outcome of that would be orders that effectively stop the bullying. So there's no capacity to get compensation for money in this jurisdiction. It's just getting orders to stop the bullying so you can return to work safely. So it's reasonably limited, and it's also limited because you have to be a current and continuing employee. So if you no longer work there, it's not an option because there's not seen to be an ongoing risk to health and safety. So the other thing to think about in these situations, if you are dealing with bullying or other adverse treatment at work, if you've suffered an injury or a worsening of a condition because of that conduct, you might be able to bring a workers' compensation claim. That's not an area I practice in, but a number of my colleagues do. And it's certainly something Maurice Blackburn can assist with, or your union, or also your doctor usually has access to the relevant forms. So, you know, often people think of workplace injuries as the classic physical injury, or that it has to be completely related to work. That's not the case. If it's in some cases, if it's a worsening or a deterioration or a psychological injury, there might be access to workers' compensation. And I think that's something that's probably not as well understood out there in the public, and it's something that, as a firm, we're very keen to ensure people can access their rights and entitlements about that. So just a little note there about workers' compensation. Now, here we are just providing a bit more detail about the stop bullying orders, just for your reference about what the Commission can order in these situations. I've just given a list of a number of orders that were given in recent decisions, which go to stopping bullying, and they can include things such as stopping a group of individuals from continuing bullying conduct, monitoring an individual who might be seen, monitoring the conduct of an employer, requiring compliance with a workplace bullying policy or the creation or the review of a bullying policy, and directing the employer to provide information and support to workers. So it's quite an interesting area because the orders are quite novel, and it allows, I guess, for different outcomes. Might not be suitable in all cases, of course, but the Commission has very broad power here to make any order it considers appropriate to stop bullying. Just a bit of a pause as I change slides, sorry. The last part of the presentation, I might just take a break to have a glass of water, but the last part of the presentation is really dealing with quite a common issue actually that we help employees with, which is providing medical information to employers and in what circumstances that should be provided and how much information needs to be provided. So an employer can have a right to request information, but it really does depend on the circumstances. So in employment law, there's this concept of a lawful and reasonable direction. And if an employee fails to follow a lawful and reasonable direction, it can be seen as a basis to terminate the employee, to discipline the employee, or to take action against the employee. So we would never want any of our clients to be in a situation where they could be seen to have not followed a lawful and reasonable direction, because that gives the employer capacity to take action and, lawful action possibly against that employee. So in some cases, an employer asking an employee to provide medical information could be a lawful and reasonable direction. So, if it's a situation where the employer has concerns about an individual's kind of capacity to do the job, or there's been an incident at work, that might be a scenario where they could be entitled to ask for more information. It also can sometimes be something that's written in your employment contract, and that's why it's really important. And I have seen it. It is unusual, but I have seen it. That's why it's very important to review your contract and make sure you understand what the employer's rights are in there and what your rights are in there as well. So in that second dot point, I've said implied or express contractual right. And what that means is it could be read into a contract, even if it's actually not written in there, or it could be expressly written in there as well. So even if it's not written in, it might be an additional obligation that's seen to give effect to the employment contract. And that just depends on the contract you've got and how it's written and how it was negotiated. The other place it might come from is in some particular jobs, there's actually a right under legislation for an employer to get medical information, and they're often, the high risk jobs like, train driving or safety critical work. And then there also might be an entitlement under your enterprise agreement. And there might be a process under that enterprise agreement by which the employer can obtain and use medical information. So when dealing with these sorts of issues, it's always important to understand the context and why the employer is asking for the information, and also to give yourself enough time to understand the request and possibly get advice, because you don't necessarily, in all circumstances, have to give the information. It really depends on the facts, and it depends on what's being asked and how it's being asked. So just because you've got a letter from the doctor, a letter from your employer asking for information, or it might be a letter sending you to some kind of independent medical assessment, don't always assume that it has to, you have to do what's said in there. You should always get advice and get legal advice, and make sure you've got enough time to do that. Now, a scenario where it might be lawful to get medical information could be where it's necessary to show that you've got fitness to do the duties. So a classic scenario might be where an individual has had a medical event or some sort of episode or flare up at work, and the employer's noticed it, and they've got concerns about the fitness of that person to continue working. In some cases, that might be lawful, or if there's some kind of indication of a need for you to attend a medical examination to confirm fitness for work. So that often arises in circumstances where someone's been off work for a long period of time, and the employer, needs clarification about if that person's coming back. Now, that's a situation where it may be lawful, but classic lawyer answer, it just depends on the situation and the circumstances, because it might not apply in all situations. So a list to think about in terms of, if you're in receipt of this sort of request is, how is the direction being given? What's the purpose of the information? How is that information going to be provided to the doctor? How are you going to get a copy of that? What questions are being asked? That's really important, because in some cases, someone might have a physical injury, but the employer's asking for a broad range of information about, their mental health or a completely unrelated condition. So it doesn't entitle the employer to just have a, fishing expedition to get anything and everything. It's really got to be targeted to the specific issue. The other thing to think about is what privacy safeguards are in place. So what protections are there for your privacy, such that it's not circulated at large and it's only dealt with by who needs to review it, and also whether you'll be paid to attend. In some cases, there might be a right under the enterprise agreement or the contract for you to have paid attendance, or in other cases, you might request it. But these are very broad considerations, and I'd always like people to get advice before they engage in this process, because often employers are trying to get information so that they can perhaps take steps to conclude the employment on the basis that someone can't do the inherent requirements. And sometimes those requests can be directed to that, sometimes not. But I think it's always important that people understand what they're being asked to provide, where it's going to go, where it might end up, because often we can intervene at that step, redirect things, maybe provide very limited information that deals with the reasonable request and might be from your doctor rather than someone like an independent medical examiner. All these considerations come up. Now, the last part dealing with employment law rights and entitlements, just a few notes on leave, because often people dealing with chronic or ongoing medical conditions do need to access leave at various points. Just a note there again about workers' compensation claims, that obviously, if a claim is accepted, that can give you access to paid leave for a particular period, and can provide a guarantee that the employer has to keep your job open for a particular period. The other place where leave might come from if you don't bring that kind of claim is personal leave entitlements. So under the National Employment Standards, you have access to sick leave. You might also have sick leave under your enterprise agreement, contract of employment, or employer policies. So there's a number of sources. The other note here is that there can be, or there is rather, a protection from being dismissed while you're on sick leave. That's a limited protection. There's a particular definition in the Act about what that sick leave is, but in some cases, if an employer is trying to dismiss you because you're on sick leave, that might be unlawful. So if that's a scenario that you're faced with, where an employer's, written you a letter saying, why shouldn't we terminate you because you've taken a very long period of sick leave, it might be unlawful for them to do that, so get some advice. The other thing to think about, and I put a note here and I've got a couple of slides dealing with it next, is income protection. And income protection is a claim that you can bring as part of your superannuation. So in some cases, if you need to cease work before retirement age, you should consider what your entitlements might be. You might be able to access your super early, but more importantly, you might have access to life and disability insurance so that you can claim via your super fund if you have to stop work or if you're terminated because you can't do the inherent requirements of the job. Your employer might also have a group income protection policy. or there might be something in the EBA or another agreement. So if you're sort of in that space, it's important to understand, I guess, where some other rights and entitlements might come from that are outside the employment law jurisdiction, but still cover, and could provide you with income for a period. So as I said, it could come from the income protection in your super. There could also be a TPD claim attached to that, or there might be employer provided super as well. In terms of what that might involve, if you're bringing an income protection claim, that could entail receiving monthly payments if you can't work or can't do key functions. And with a TPD insurance claim, it's not usually the case that you can't do any work at all. It might just be that you can't do work that you're reasonably suited to, taking into account education, training, and experience. So it's a bit more technical than you might think, in that you might have access to this even if you can do some work. So again, Maurice Blackburn has a number of lawyers that practice in this area, and we'd be happy to provide further guidance on that point, depending on your situation. Lastly, as I said, that employer provided policy, there might also be some claim available, and you would certainly want to be getting advice about whether you should make that claim before you cease employment or before you're terminated, because some of these insurance policies provide really strict carve-outs about that. So I've just provided a link here and a contact number if you'd like to get more advice about that point. I think it's often something that people don't necessarily think about. And even if, you've got people in your life who might have had a serious injury or a serious accident, often this is something that people forget. People generally think about work cover and TAC, but there's also this other insurance out there. And if you're entitled to it, it could provide quite a substantial, degree of protection in terms of providing you income. Now, I think that's all I had to say. I'm sorry it took a bit longer than I thought, but I think we've got about 15 minutes for questions, which I think Jen is going to facilitate.
Thanks very much, Jess. That was a very comprehensive, and you did a presentation. You did a great job of explaining, what might to some people be quite complex concepts and components, but I've found it fascinating myself, and hopefully that sort of, in a way, gives people a bit of understanding of some of the sort of the basic entitlements within a work environment. I think it's important to remind people that everyone will receive a recording of this webinar, so they'll be able to re-watch it if they want to go over any points that you covered and so on. So thanks very much for a really great presentation.
Nice.
Could I encourage everyone to type in now any questions that they may have with regards to Jess and what she's covered this evening. Just one sort of note, keep the questions to a fairly general nature if possible, because Jess is not really in a position in a sort of a public forum like this to actually answer very sort of detailed personal questions. But that's one thing that I wanted to ask you, Jess. Even if someone has a fairly small query with regards to something that's arisen at work, can they just contact Maurice Blackburn at no cost to actually just seek some fairly simple advice, or does it have to only be in the event of a serious matter?
Yeah, good question. So we have a number of different sort of teams that have different processes for providing advice. And the way that our team, the employment law team, is that people need to contact us for initial consultation, which is usually an hour. If the person's a member of a union that we're affiliated with, they can have a free half-hour appointment. So always just check with your union if they're happy to give you a referral to speak with us. Often we find that even the simple questions can sometimes need a bit of unraveling, and hopefully we can cover that in the hour appointment. Our work cover team operates slightly differently, and they're, I think, able to take or provide very brief advice in some cases. But usually we say the first point for us is to come in for that longer appointment. And sometimes people will see us when things have gone, really, really wrong, and it's kind of at crisis point. And other times people will see us well before that, so we can set them up to deal with situations and scenarios that come up. So I think things are always, it's always good to be prepared if you can be, and get the advice early. But in some cases, you just have to see how the scenario plays out.
Yes, another thing I was interested to note was the time limits that are on various
Yeah.
provisions. You mentioned it and so on. Has that been brought in for what reason? Or why do
I
they
think,
exist?
yeah, that's an interesting point. I think with the discrimination time limits, it might, and look, this is just a guess, but it might be to do with fairness to the other side in which the discrimination's been complained about, so that they, can have access to the relevant witnesses that recall the event, perhaps. But then, it might be 6 or 12 months in a discrimination claim, but 6 years in an adverse action claim. So maybe that doesn't make sense. I think the claims about dismissal, so your unfair dismissal and your general protections, the Fair Work Commission tries to deal with those relatively quickly because the remedy there is often someone being reinstated back to their job. And the longer you wait, obviously, the harder it is to go back to the workplace because things have changed. So I think that's the rationale for that one. But 21 days is a very short amount of time.
Okay. We have a question that's come in, not too personal in nature, but it sort of gets to, the issue around reasonable adjustments. This person has written that after working for decades in their job, they sustained a work injury and was found to have osteoarthritis in their knees. Can they request that they are excused from lifting and pushing heavy loads?
Yeah, interesting question. So just to clarify, the person's been in that job for a while and this injury or this condition's worsened over time.
Yeah, so the injury appeared, but also obviously revealed or exacerbated osteoarthritis that had existed in their knees.
Yeah, understood. So again, it comes to the question of, is this lifting requirement essential to the job? You would say that, and it's hard to say without being specific about if it is or it isn't, but what I would usually say is that you should try and have a discussion with your employer and also go into that discussion with medical evidence that says what adjustments you need, because, you obviously don't want to be in a situation where you're saying that you can't do what is a key duty of the job, but then you also don't want to be in a situation where you're putting yourself at risk of further injury. So I think going into a discussion with the employer armed with some medical evidence about what adjustments you need and how long that might need to happen for, I think is really useful. Unfortunately, the reasonable adjustments does come down to how big the employer is and what their resources are and how significant the changes are. And there might be some scenarios where they might say, well, you're our only employee, we can't have you not lifting a box, but you'd think in most situations it would hopefully be reasonable for that adjustment to be made. But you can't definitively say, it's fair or it's not fair because it does depend on the employer's situation too, as well as the employee.
Jess, I think you mentioned that you don't specifically deal with superannuation queries, but one person has mentioned that they did have 1 or 2 superannuation accounts, and both were terminated with the insurance cover component also being terminated following recent government changes, and they wondered whether there was any avenue to pursue the fact that the insurance component no longer existed and they may have a need to access that.
Yeah, I'm not I would have to say I don't know the answer to that. I do know it has happened, but I can reach out to one of my colleagues and get back to you with an answer, Jen, about that one.
Yeah, okay. Well, we'll send that specific question to you and see what you can do in follow-up. That'd be great, Jess.
Sure, no worries.
We have a question about is it lawful for an employer to ask for medical information when applying for a job and be even before being offered the job? Being given a bunch of forms to fill in, and amongst them is a medical form asking about any spine conditions, etc. I've experienced this when applying for a apparel retail management job. So I guess you did talk before about the sort of the need for disclosure or not. So yes, so that's interesting about the person has actually been offered the job and has to fill in medical forms as part of that sort of finalisation of the employment.
I think it would depend. Often employers will frame that as, well, we have a duty to give you a safe workplace and that this inquiry is relevant to that because it's a physical job. And I think if it's framed in that way, it might be reasonable. But what you might do is inquire with the employer, you know, why do they need this information and where will it go and how will it be used? I suppose when you're in the job, it might be an easier conversation to have them, you know, before you get the job. But I would perhaps make those inquiries to get an understanding of why it's being asked. I can't say in all scenarios it would be unreasonable. I can think of scenarios where it would be unreasonable, but depending on why or how, we'll go to how reasonable it is.
There's another question about, is it reasonable to subjectively compare a new employee to others previously in the role? But I'm not quite sure whether that question really sort of relates directly to whether a person might have a chronic health condition, specifically musculoskeletal health condition. So look, I might leave that one and ask that person to maybe clarify that question further if they have an opportunity. This is more of a comment rather than a question. Such a great presentation, clear and thorough. Now we're looking to return to the office. Reasonable adjustment, something to consider to work from home for some time. It's interesting. Someone who was a teacher and working from home last year during COVID and has a musculoskeletal condition did make the comment about it would be nice to be able to continue working from home in her teaching role. Given that normally in the past she would have been required to attend the school to teach, but in fact was finding that she was able to do her job quite well from home. So what's the situation when, say, the majority of teachers might be required to return to work, to the workplace, the school, but in fact it's been found that doing the job from home is okay and would suit this person better given that they have a musculoskeletal condition and maybe different aspects that affect their sort of attending the school as their workplace.
I think this question is going to come up more and more because people are realizing that their jobs can be done from home, and for a lot of people with caring responsibilities or medical conditions, it makes life, you know, more bearable and you know, more comfortable. So I think this issue will come up a lot. The difficulty is that often people are employed under their contract to work at a particular location or to do particular duties. And often those duties or locations either state explicitly or imply that involves attendance at a school or a work site. And if you're engaged in that role or duty, arguably one of the inherent requirements is attendance at the location. So that's a difficulty. Often the way I suggest people deal with it is to get some medical evidence about what adjustments might make things better for your work. So could working from home 2 days a week or 1 day a week assist, and getting your doctor to provide some medical evidence supporting that view if they have that view, and then having a discussion with the employer about whether that can be accommodated. You know, you sort of need to be careful when you're having those discussions that you're not presenting a position where you say, I can't work from school at all and I can never do it, because the employer might be able to lawfully turn around and say, well, we employed you to work at the school and do that job. If you can't do it, we'll find someone else. So it's quite a careful conversation that you need to have when you're in that area, and you need to be supported by your doctor. And I think, you know, to a degree, you need to offer options to the school about how it could be managed. So, you know, could you do one-on-one tutoring for that time, or, you know, are there things that can be done, and offering solutions as well as being firm about what your requirements are too. But it's hard. It's a hard conversation, I think.
Yeah. And just the mention of superannuation towards the end, in relation to the sort of total and permanent disability or needing to access sort of some of those funds if you have a chronic health condition that's affecting you know, your life in general. Sometimes it sounds like some superannuation groups or companies play fairly hard ball with regards to accessing that money. Again, I know it's not your specific area, but is that your broad sort of knowledge that sometimes it takes a bit to those funds to be entitled?
That's right. I can definitely speak to that because I know we have a number of lawyers who practice in these areas and help people access their claims. You know, insurance policies are drafted a particular way to, you know, provide that certain hurdles that have to be reached in order to access the compensation or the entitlement. And often they're applied one way by an insurer, and we might say they should be applied another way. So it's quite a big area of our firm, and I would say it's reasonably common as well. Yeah. But if you're in that scenario, reach out on that contact number I provided, I think on a couple of slides earlier, and see if there's something that we can do to assist there.
Yep. Okay, look, that seems to be no further question from our audience this evening. So, look, on that note, I'll thank you again, Jess. That is really invaluable. And as I said at the start of the webinar, given that the majority of people with musculoskeletal conditions are actually of working age, you know, its information is incredibly important and relevant to so many people. So, even if for people who haven't viewed the webinar tonight, this will be on our website and freely available to other people who may need to access this information. So as the person commented, it's been a very clear and thorough presentation. So I thank you very much for that. I thank the people who have joined us this evening, and also ask if you take a moment to fill in the feedback survey that will come on your screen shortly. And also remember that our next webinar will be at the end of April, and it'll be on the topic of pregnancy and arthritis. So on that note, thanks again, Jess, and I wish everyone a very good evening. Thanks and good night.